First and foremost, we have with us our special guest, Mark Ellis from the International Bar Association in Ukraine, and he is a well-known person in the European legal community. He specializes in international criminal law, and his experience, his knowledge is very important for Ukraine right now to establish a firm position of our state and for holding the Russian Federation responsible for their actions. So we offered Mr. Mark Ellis to make a special presentation to set the ground for our subsequent conversation. Mark, the floor is yours.
Well, I want to thank everyone for this invitation to be here. It was a bit of a journey to get to Kyiv, but it's something I wanted desperately to do, to be here in Ukraine. I have been here before, prior to the wars, but I thought it was important to be here in solidarity with our Ukrainian citizens and friends. I wanted to talk a little bit about this issue of accountability, but I wanted to take you back to a time when in 1989, in November, I was in East Berlin at the time, and it was the exact week the Berlin Wall fell. And Gunter Schabowski, who was the head of the East Germany Communist Party, police, I think decided unwittingly to open the border. And so the next morning, a sea of people started moving from the east to the west. And I was actually one of them who moved in that direction. And so much was about to change. A door to freedom had opened, and we were at the cusp of a transformation that would soon engulf Eastern Europe. But more importantly to me, it signified the end of the Cold War. And it was beginning of a new kind of peace. And as Paul Krugman said, it was one of history's miracles. But the fall of the Berlin Wall also signaled the resurrection of the principle of accountability. That principle was brought to us after World War II. And by the end of that war, the international community had set in motion a lasting and irrevocable effort to enshrine anti-impunity stance in international law. And that is a concept that is a core to international law today. And it is formed by what we call the Nuremberg Principles. And those principles make very clear that the fact that a person who committed these crimes is a head of state does not relieve him from responsibility under international law. And coupled with this principle is the prohibition to impunity and a commitment to accountability. So any person, regardless of position, who commits an act that constitutes crimes under international law is liable for punishment. And World War II also enshrined a number of accountability mechanisms to ensure that no immunity exists for gross violations of human rights and international law. And so we know a series of conventions came about: the Genocide Convention, the Geneva Conventions, the Prohibition on Crimes Against Humanity. They are today the binding, customary international law that marks a prohibition from granting any immunity for atrocity crimes. And of course, as we know, in a unique collaboration, mechanisms to support accountability emerged. They proliferated: international courts, regional courts, domestic tribunals, all of it aimed at ensuring that there is accountability. But this golden age of international justice is now facing significant challenges. And the arbitrary exercise of powers by government, powers that erode human rights, is taking hold, in no place more than in Russia. In The Open Society and Its Enemies, published in 1945, the philosopher Karl Popper warned of totalitarian ideology in the post-World War II period. For me, the problems he wrote about are now manifest. Russia's ultra-nationalistic agenda, as exposed in its war of aggression against Ukraine, is the single most danger of the foundation of international order since World War II. International law is clear and absolute. A state is prohibited from the use of threat or force against another state. All instances, regardless of their manifestation, regardless of the gravity, constitutes a violation. And unfortunately, Russia has violated this sacred principle. Vladimir Putin may believe that he is immune from being held liable for these crimes, but he is not. As set forth in Nuremberg in terms of atrocity crimes, customary international law is clear. Impunity for state officials like Mr. Putin does not exist. And in short, today, we continue to advance the position that violations of international criminal law do not warrant immunity protection. And because accountability is now the core of international law, the international community must work together to ensure those who have committed crimes here in Ukraine are brought to justice. That is a responsibility of the international community. There are, for me, 4 ways to pursue this type of justice, and each is part of a mosaic of international justice. The first is domestic accountability. And of course, with the amendments to Ukrainians' law back in May of 2021, Ukraine Parliament has brought the legislation up to standards that meet current international law and the Rome Statute. And so under the principle of complementarity, Ukraine can and is undertaking domestic war crimes trials against Russian personnel. And they continue to do so, and they should do so. But there are 2 points I want to make on domestic prosecutions. And this is something I've learned in other post-conflict environments. One is about domestic capacity, the capability of undertaking crimes. And the second is about fairness. I recognize that as to the fairness, the focus will undoubtedly be seen as somewhat controversial. But Ukraine's ability to show the world that it is able to conduct domestic war crimes trials consistent with international standards of fairness and impartiality will be the part of your legacy, the part of Ukraine's legacy. And second, increasing assistance, training to those here in Ukraine involved with undertaking domestic war crimes tribunal is also important. Under the best of circumstances, undertaking war crimes trials is very, very complicated. But to do so in a situation that we have now, in a conflict, active conflict situation, undertaking war crimes tribunals is exceedingly difficult. But international assistance can help. The second of the four is the International Criminal Court, as you know. Russia is not a state party to the ICC, and of course neither is Ukraine. But Ukraine accepted the jurisdiction of the court, and that is sufficient. And even though Russia is not a state party, the distinction does not matter. It has committed crimes on the territory of Ukraine. Ukraine has accepted the jurisdiction of the International Criminal Court, and therefore has jurisdiction to pursue those who have committed the crimes. And as you know, the ICC has an active investigation on those crimes. But the question is whether the ICC can bring Mr. Putin to justice and other high-level personnel in Moscow. I believe it can do so, and I believe it should do so. And it can do so under the legal concept of command responsibility. And this allows the court to look at individuals either in civilian or military positions that have effective control over the situation here in Ukraine. And in having effective control, that person knew or should have known that the crimes were being committed and did nothing to stop them or punish them. It is unquestionable, in my opinion, that Mr. Putin has effective control over the decisions of military intervention and operations in Ukraine. So in essence, Mr. Putin can and should be prosecuted for the crimes under command responsibility, even though he's not the one directly committing them. The stature of Mr. Putin would undoubtedly see him as untouchable, and I suspect he feels the same. But this is what I say about this topic and the types of international crimes. There is no statute of limitations. There is no impunity. And it does not matter the position you hold. And although Mr. Putin may believe that in the short term he has protection, and he may very well have, I always say that international justice plays the long game. And history has shown that with Milosevic, with Karadzic, with al-Bashir, with Charles Taylor. Eventually, the tide turns. The third part of the mosaic is the crime of aggression. And this has already been mentioned, and it is probably the most focused and most interested among people, certainly in Ukraine. I know that the recent political declaration here of the ministerial Ukraine Accountability Conference has focused on the crime of aggression. Although it did not directly mention a tribunal for the crime of aggression, there is clear acknowledgement by them that Russia has committed an aggression against Ukraine. However, I think it's important to know that undertaking a process for the crime of aggression is not easy under international law. It's challenging. So, like the other international crimes, we can be certain that the crime of aggression is embedded in international norms as set forth in Nuremberg. It is a norm of international law that cannot be derogated from. It is also a leadership crime. So it can only be committed at a level of leadership that has effective control. And as I've stated earlier, Mr. Putin does in fact have that effective control and therefore can be targeted. But the international community continues to recognize the crime of aggression. As we know, the UN the UN General Assembly, the UN Human Rights Council, the UN Secretary General, many others have clearly stated that the crime of aggression has occurred. In that I have no doubt. But to implement a procedure for the crime of aggression is challenging. Ukraine could enter into an agreement with a group of like-minded states, even within the UN, to establish a dedicated tribunal for the crime of aggression. And this would, I think, be the best step because of the need to bring in international players. It could also create, through the European Union or the Council of Europe, or some type of hybrid European regional tribunal. That too, I think, is possible. And there's already meaningful cooperation in discussions, Oleg mentioned that as well, about doing some type of tribunal. And finally, there is the possibility of a Ukrainian version of a special tribunal specific here in Ukraine that would be focusing on the crime of aggression. Here, I believe, if that's the case, it would need technical assistance, I believe, for that to succeed, whether it's a special chamber or within the current structure. For me, it's the same. But there is an issue for me. The crime of aggression is an international crime. The international community should be part of any prosecution against Mr. Putin for the crime of aggression. I do not believe it should be left to Ukraine alone to do so. This is where the international community, I believe, must be part of the effort to pursue Mr. Putin. And finally, as part of this mosaic, is universal jurisdiction. And universal jurisdiction, which is being considered by a number of states, particularly in Europe, is defined by a legal principle that says it requires all states to bring criminal proceedings in respect to international crimes, atrocity crimes, irrespective of the location of those crimes or the nationality of the perpetrator or the victim. And the rationale for the universal jurisdiction is that there are certain crimes that are so critical that the entire international legal community at large are obligated to pursue justice against perpetrators. But here too there are challenges. Many countries have adopted restrictive measures, conditions on the universal jurisdiction principle. So it's not as easy as it was before to pursue justice against, for instance, Mr. Putin from a European state. But finally, the most important thing that is a challenge to either universal jurisdiction being used by other states or Ukraine doing it domestically is the issue of head of state immunity. And you might say, well, Mark, you just talked about the importance of no impunity for head of state. And that is true, but that's within international tribunals. When you move to domestic state mechanisms, the fundamental principle of head of state immunity still applies. So it's odd, isn't it, that if an international tribunal can pursue a sitting head of state, as many have done, but a state cannot because of this embedded international principle of impunity. However, there's still a way forward. There are impunities that are personal impunity, they're called personal immunities and functional immunities. So personal immunities protects the sitting head of state. So it does protect Mr. Putin if a state, including Ukraine, would try to pursue justice. But that personal immunity only lasts so long as Mr. Putin is in office. As soon as he leaves, that protective nature disappears. And that's an important distinction because, as I said earlier, heads of states who have committed these types of crimes, they think they're protected forever, but time and time again, they lose that protection, they lose the support. And history shows that, again, that occurs. And then there's functional immunities. And functional immunities last forever. So if one argues that a head of state in his function as the head of state is undertaking certain acts, as long as they're seen as a function of his office, they're protected from any attempt to prosecute him in a state, including from Ukraine. But here's the difference. Functional immunity on international atrocity crimes is now beginning to disappear. There is a growing emergence that crimes committed in the function of an office that includes atrocity crimes, they cannot be an official function of the office or the individual. They must not be protected. We saw that in the Pinochet case in the UK. So that's hopeful for any approach to Mr. Putin, even if it's done in a European state or in Ukraine, to be able to move beyond the hurdles of head of state immunity. So in conclusion, let me say this, that the universality of human rights and territorial protections, economic integration, the fortification of democracy are all under threat by Russia's war against Ukraine. And it's not just a threat to Ukraine, it is a threat to the international community if Russia succeeds. But there is, for me, one positive aspect of this crisis. It is the attention being paid to the ideas of justice and accountability in international law, just as we're doing here, focusing on it. Even though Russia is violating the most sacred principles of international law, those actions are galvanizing many other countries who now understand the importance of protecting the principles of international law. Never in my lifetime have I seen so much focused on ensuring justice and accountability as I've seen now with Russia's war in Ukraine. The community, the international community, understands that these principles are under threat and they are being weakened and they must be protected. And I think there is a revelation now, an awareness of the important role of international law, and a greater appreciation and acceptance of the importance of these principles, in that by upholding them, we will be better as an international community. We owe this to Ukraine. We owe it to Ukrainians for the international community to join Ukraine in ensuring that justice is held. Thank you very much.